Major difference between the US and UK legal systems by an article by Pia Alexia. Attorney probably already know legal systems in both the UK and the US share the same historical common law roots and are for that reason quite similar. The purpose of this post throw is to highlight a few of the key differences in order to give attorney a sense of how the US and UK legal systems differ. Much like the main subdivisions of the UK, for example England, Wales, Scotland and Northern Ireland, the states of the US have their law, court systems and bar associations. In the US, federal law and court decisions generally take precedence over the states' laws and decisions. Power, not guaranteed by the federal government, are instead specifically reserved to the states in the US Constitution.
Court systems in both countries are quite similar. Minor criminal offenses and small civil disputes are handled by special magistrates courts tasked with resolving such disputes. In the US, there are cases for state courts almost exclusively. More serious crimes and civil cases in both countries are then subject to three-court hierarchy. In the US, at the federal level, criminal cases and civil cases are not heard by separate courts. At the state level, however, many states do have separate court systems for these two types of cases. Cases begin in lower courts, Crown Court in the UK, District Court in the US. Then move on to courts of appeal and are finally resolved in a single Supreme Court if it is necessary. It's important to note that the US does not have a tribunal system as the UK does for certain disputes. There are, however, niche courts for certain type of cases. For example, bankruptcy court is a separate type of federal court. In the US, parties may also agree to submit to binding arbitration or mediation as a means of alternative dispute solution in certain cases. This often provides a less costly, more streamlined and less adversarial way to conclude conflicts.
Much like courts in the United Kingdom, courts in the USA rely mainly on past judicial opinions are authoritative present when resolving litigation. In the USA, these are often referred to as opinions or simply case, while the phrase law report has become somewhat archaic, as readers will also likely know. For legislation, the USA has two centralist federal bodies, the House of Representatives and the Senate, which are similar to the House of Parliament. Each of the 50 states in the USA is afforded to senators, while representatives allocate proportionally based of each state population. In order to become a law in the USA, a bill under discussion must be approved by the majority of both congressional bodies, and then signed into law by the President. If the President refuses to sign the bill into law, his or her veto can be overridden by the two-thirds majority vote in Congress.
The role of lawyers in both countries are quite similar. The terms barristers and solicitor are not commonly used in the US, and litigators and non-litigators are not separately licensed. Once an attorney is admitted to the bar in a particular state, he or she may generally practice a king of law. For the sake of clarity, court-going barristers are known as litigators in the US, and solicitors are called corporator or transactional attorneys.
In the UK, there is not a requirement to pursue further courses and apprenticeships beyond law school. Instead, in the US, all prospective lawyers take a 3-year course at an accredited law school and receive a Juris Doctor degree upon graduation. Then, a student must pass the bar exam in a state of their choosing. After licensure, they may generally practice law school in any field of their choosing. As you can see, these systems are more alike than they are different. Hopefully, this post can serve as a basic guide so that attorneys can get a sense of how the two systems compare. If you're interested in learning more about the US law and how it differs from other countries' legal system, consider an LLM in US law.